5 seconds to go. Start. However, we are in agreement with the submission that having regard to the stringent provisions of MCOCA, its provisions will have to be very strictly interpreted and the authorities concerned would have to be bound down to the strict observance of the said provisions. Stop. There can be no doubt that the provisions of MCOCA have been enacted to deal with organized criminal activity in relation to offences which are likely to create terror and to endanger and unsettle the economy of the country, for which stringent measures have been adopted. Stop. The provisions of MCOCA seek to deprive a citizen of his right to freedom at the very initial stage of the investigation, making it extremely difficult for him to obtain bail. Stop. Other provisions relating to the admission of evidence relating to the electronic media have also been provided for. Stop. In such a situation, it is to be seen whether the investigation from its very inception has been conducted strictly in accordance with the provisions of the Act. Stop. Para. In relation to the particular fact situation concerning the individual accused persons, this court found that the sanction had been granted with complete non-application of mind and hence, disapproved the same in the following words, para. In the instant case, though sanction had been given by the Special Inspector General of Police, Kolhapur Range, on 31st August 2004, granting permission under section 23(1)(a) of MCOCA 1999 to apply its provisions to the alleged offences said to have been committed by Anil Nagpal, Lalit Nagpal and Vijay Nagpal, such sanction reveals complete non-application of mind as the same appears to have been given upon consideration of an enactment which is non-est. Stop. Even if the subsequent approval order of 22nd August 2005 is to be taken into consideration, the organized crime referred to in the said order is with regard to the alleged violation of sales tax and excise laws, which, in our view, was not intended to be the basis for application of the provisions of MCOCA, 1999. Stop. To apply the provisions of MCOCA, something more in the nature of coercive acts and violence is required to be spelt out so as to bring the unlawful activity complained of within the definition of start organized crime close in section 2(1)(e) of MCOCA. Stop. Para. In our view, both the sanctions which formed the very basis of the investigation have been given mechanically and are vitiated and cannot be sustained. Stop. In taking recourse to the provisions of MCOCA, 1999, which has the effect of curtailing the liberty of an individual and keeping him virtually incarcerated, a great responsibility has been cast on the authorities in ensuring that the provisions of the Act are strictly adhered to and followed, which unfortunately does not appear to have been done in the instant case. Stop. Para. In the case of Ranjit Singh Brahmajit Singh Sharma Supra, during the tenure of the appellant as Commissioner of Police, Pune, fake stamp papers worth rupees 2.91 lakhs were seized, whereupon an FIR for offences under sections 120B, 255, 249, 260, 263A and B, 478, 472 and 474 read with section 34 IPC was registered. Stop.